established in 2012 after they made some revisions to the open meetings and the Open Records Act. But all of the revisions are still active, so this is still all accurate information. And I just want to hit the highlights for you guys, because I think you all have a general sense that the presumption is meetings are going to be open. The presumption is records are going to be open and available for the public. So I want to really drill down on those narrow exceptions when that isn't the case. So one, and I'm just going to skip through these and hit the highlights as I said. So the first highlight I want to hit for you is on slide 6, the definition of a meeting. You'll see that it's a gathering of a quorum of members of a governing body of an agency, and that includes the Cobb County Board of Education, in which any official business, policy, or public matter is formulated, presented, discussed, or voted upon, or the gathering of a quorum of any committee of the members of the governing body, same thing. One interesting thing about the Open Meetings Act, while meeting is pretty well defined, official business is not. So that is a gray area for us that the Attorney General hasn't defined in statute as yet. My suggestion to you is err on the side of openness. I think that's certainly the intent of the Open Meetings Act, sunshine being the best disinfectant, that being the theory, that you err on the side of openness. The Open Meetings Act does specifically exclude certain gatherings, even when a quorum is present, from the definition of meeting. So they're not subject to the Open Meetings Act.
I want to back up to the definition of meeting, so that Dr. Irwin and I don't get something else. So,
I don't want anyone to
right. Because the gathering or quorum of any committee, so we're a committee of two. If the two of us are participating, it's the quorum of that committee, not the board as a whole.
That's the plain language of the statute.
Okay. Which would mean that whenever we have an ad hoc committee,
You notice it, you hold your
notice it, hold it open. Okay. So I think that's follow the same procedures as the body as a whole.
So there are some things that aren't meetings, even when a quorum is present. When you're inspecting physical facilities, if you are at a statewide meeting or a statewide training, if you're meeting with other agencies, you're perhaps meeting with your legislative delegation. When you're traveling to places, let's say you all want to carpool somewhere and you can put 4 people in a car and save on some gas. Or if you're at social or ceremonial events, say we have a cocktail reception for you, you're welcome to come here and not have it be an open meeting. Remember, though, that you can't conduct any official business at those meetings. Again, we have no definition of official business, so my suggestion to you is to keep it social. Another thing to keep in mind, these exceptions don't apply if the purpose of gathering together for the statewide meeting or travel was to evade the purposes of the Open Meetings Act. So for instance, 4 of you can't get together and say, you know what, let's all carpool down to this meeting that we have. It's travel, so it's not an open meeting, and we're going to get some business done there, and no one has to know about it. If your purpose is to evade open meetings requirements, these exceptions don't apply. General rule for open meetings, they've got to be open to the public and the press. They can observe and report. They don't have the right to participate in the meeting, but they do have the right to observe. You can certainly allow the public to participate, and you do, through your public comment sections. If you vote on any matter in violation of the law, it's like the vote never happened. It is void. And challengers to the action have with it up to 90 days of the vote to challenge it in court, or if the vote was actively concealed, another 6 months. You want?
So that means then, I just want to make sure we understand, not that we do this, that the votes are voidable as opposed to void?
That's right.
Okay, so that's important.
I mean, basically, just like any other violation of statute, there's a statute of limitations on challenging an action because you don't want something to live forever as a potential controversy. So you've got 90 days after an invalid vote to challenge it, or 6 months to conceal. As part of your open meeting, you certainly want to notice the meeting itself, the date, time, location for your regular meetings. You do that in January for the year under regular meetings. But special meetings, if you can, usually require 24 hours notice unless there are special circumstances that prevent you from providing that kind of notice. There should be very few and far between better. More notice is better than less notice. And we also need to post our agenda in advance, so the public understands the business that we're going to be discussing, that we're going to be acting upon. And we shouldn't be acting on any items that are outside of the agenda unless it is necessary to do so. And again, those matters should be few and far between as well.
A month or so ago, you had mentioned that we shouldn't be acting on things unless it's an emergency. And the letter, as you just said, is if the board needs it necessary. So I would say there's two different connotations.
It's not the exact wording, but the purpose of this statute is to make sure the board is not conducting any business that hasn't been properly noticed to the public. Because if it's not absolutely necessary to take an action when it's not on an agenda, then you shouldn't be taking an action that's not on a publicly noticed agenda.
Well, OCGA says of all matters expected to come before the agency. And if they leave out expected, it's all matters to come before the agency. So expected is in there for a reason. It gives the board some obviously. And the word necessary versus emergency. So it seems like, I feel like you're trying to give us less leeway than OCGA gives us.
I think if you were to ask the Attorney General, and the Attorney General's the office that monitors and looks at this statute, the Attorney General's office would tell you, if it's not an agenda, you better have a darn good reason as to why you're acting on it. And that reason has to be compelling, because what you're doing is you're taking an action the public has no business about, have no opportunity to contact their elected representatives about. So those should be very few and far between.
I beg to differ. I see boards all the time making motions and moving things that weren't on the agenda. And nobody seems to open their arms about it.
My suggestion to this board is to notice action and to not take action on things that the public doesn't know about unless you act.
Understood.
So we need to have minutes of our meeting, and we also need to have minutes of executive session as well. The final minutes need to state the agency members that are presenting a motion, that describe the motion, state who made the motion, second the motion, and record all the votes. And unless the vote is unanimous, we need to record who voted for it, who voted against it, who abstained. We also need to keep minutes for executive session. These are not available for public inspection. Rather, they're used to memorialize what was discussed and done in executive session in the event of a dispute. And if there is a dispute, the law provides that the court can conduct what's called an in-camera inspection, which means it's only the court that gets to see it to determine whether or not the executive session is correct. You can hold closed meetings or executive sessions with your counsel to get advice on actual and threatened litigation, and it's got to be a real threat of litigation. It can't just be this sort of employee worry that, oh, we might get sued about something. It's got to be an actual threat. Please understand also, just having your counsel present doesn't magically turn a discussion into an executive session. It's got to be about the actual or threatened litigation. You can also talk about things like the acquisition or disposal or lease of real estate, but you've still got to vote on it in public to make it effective. You can also use executive sessions for personnel matters when you're discussing or deliberating specific personnel issues or interviewing applicants for the position of the head of an agency like their superintendent. I think the most common way that you will use this exception is when you are sitting in your capacity as sort of the judge for fair dismissal hearings regarding your personnel. And typically what happens is there is a public hearing after a recommendation for non-renewal or termination or suspension is made. And that hearing is open to the public. Either you as board members will sit and hear the evidence in that public hearing, or you will designate a tribunal to do so. But when the evidence is in, and that is a formal receipt of evidence subject to evidentiary rules, but when that receipt is in and you are there to deliberate, you can do that in your closed session. Any vote that you take has to be taken in public. Just like with your superintendent search, you can interview candidates for your superintendent in a closed executive session. But when you vote on your superintendent, that will be a public vote. Just like anything else.
Would you reiterate that? Because I can anticipate the meetings that we will be having in the very near future. I want to be very clear on our do's and don'ts that relates to interviewing candidates and meeting about candidates. So just for the purpose of understanding, you reiterate this.
Absolutely, absolutely. When you're interviewing candidates, when you're talking about individual candidates for your superintendent, this can be done in closed session. And remember that you have requirements to keep private things that are done in executive session private. But when you vote on your superintendent, that is a public vote. Just like everything else you do regarding your official board business, going into executive session requires a vote. And your presiding board member, your chair, or in your absence, the vice chair is in charge of keeping everybody in line. Or if you choose to have your counsel there for executive session, your counsel can help as well.
Question. Have we been doing that second point about executing the chair executing this one?
You guys sign it.
What I know, I'm just looking at the language of that, and it's not a sworn, I know we signed it.
I'm a notary.
Oh, you see you?
I'm a notary.
Okay, so you're good, right?
So we're all set.
Okay.
Okay, so are we going to sign those today?
No, because we're not in executive session today, but when we do go,
I'm talking about when we do have that executive session, we do sign them.
you sign that long legal sheet, and then I take it back, and then I notarize it and file it.
Right. Also, we would be asked to sign an affidavit,
Oh, the confidentiality agreement related to the search.
today.
Yeah.
in order to submit the search, so
I have
you
copies
would sign them today.
for anybody who needs a copy to sign.
So that's the high-level 1,000-foot view of open meetings. The other side of the coin, when we're talking about Georgia Sunshine Laws, are open records. The law presumes that every document within the possession of the DeKalb County School District is open to the public for review and inspection, pardon me. There are some exceptions to that, but those exceptions are always narrowly construed, just like exceptions to the Open Meetings Act are narrowly construed. And when in doubt, the law is pretty clear that they want us to err on the side of disclosure rather than not providing access to the public. So what's a document? Basically, anything, any piece of information, whether it be written down, whether it be an email, whether it be a data field, whether it be a voicemail or a tape or a video, is an open record, unless it falls into one of these exceptions. The 2012 revisions to the law made clear that the law presumes immediate access to requested records within 3 business days from the request. Now, of course, there are times when it is simply not possible to make all of those documents available within 3 days. There may be very expansive requests for information. There may be requests for information that require a lot of redaction and review to make sure that we're not letting out information that is becomes confidential, like attorney-client privilege documents, or documents that might be protected by the Family and Education Rights and Privacy Act that protects student privacy. In that case, what we are charged to do as a district is to provide an estimate about how much it's going to cost, how much time, and about how long it's going to take for us to get that information to the requester. The law makes clear that we can charge 10 cents a page for copies if we choose to. We don't have to charge 10 cents a page, but if we want to, we can.
Is that a limit?
That is a limit, 10 cents a page. That's it.
Just change.
I thought the limit was 25.
It used to
now
be,
it's
it's
10.
changed, yeah.
Yep. And the thinking behind this, if you listen to the AG's office and their sort of commentary on this is, look, this is a new day and age. Not everything everything has to be paper. You can scan things onto a CD, you don't have to make copies. Let's not let paper be the barrier to open access. The district can also charge for the search and retrieval. The first 15 minutes are free. So we don't charge for 15 minutes, and you have to charge the rate of the lowest paid person who could do that. So you can't just say, we're gonna use the
There'll be a
superintendent.
war around.
Right.
I'll start asking y'all to do this.
And please understand that even if the costs actually exceed what your estimate is, you can't pass those costs on to the requester.
So you gotta estimate good.
The lowest paid person who can do that. So for instance, there may be times when you need to have an attorney review documents to make sure that you're not letting out anything that's privileged. But you can't pass on the cost to the requester of that. Sometimes we get requests for documents that are hugely expensive. And we think that it might cost more than $500 to comply, whether it be for copying, whether it be for time. Just the volume of the request makes it really difficult or cumbersome or labor intensive and resource intensive to comply with. We can condition production of those documents on prepayment if our estimate, and it's got to be a good faith estimate, we can't unnecessarily inflate things, is over $500. In this day and age, we also have a lot of electronic data that we keep, whether it be data fields, whether it be emails, that falls into that category, text messages, voicemails, all those kinds of things. All of that is considered open records as well, under the open records statute. And we have to make that available as well as cost effectively as well. Please keep in mind that once email is sent, it really is there forever. There's really no deleting an email. We usually will have it on the server somewhere. So it's our duty as a public agency to go get it. My advice to you is, and to everyone within the district and every public employee out there, is to use your personal devices for personal work and your business devices for business work, and keep those two things separate. There's another exception for copyright. The immediate example I can think of for this is in the world of special education, we administer a lot of test protocols to determine whether or not students are students with disabilities and what their needs might be. A lot of those test protocols are copyrighted. That doesn't mean that the public doesn't get to see a blank copyrighted test protocol, but it does mean that we don't have to make a copy. There is a broad exception in the Open Records Act regarding privacy. If something would, if disclosure of a document would violate the privacy of an individual, no one's ever really gone into what that means. But I will tell you that the courts and the Attorney General's office are very, very, very skeptical of general assertions of privacy. So please don't count on that as a catch-all to keep documents away from disclosure. There are some specific enumerated exceptions to public disclosure, things that are relatively straightforward, social security numbers, personal credit card information, health information, personal email addresses, that kind of thing. And for public employees, including teachers and everyone in this room as well, to the extent that you're a public employee, all of this information can be held confidential as well. Personnel files are public, with the exception of things like social security numbers, home telephone numbers, personal email addresses, and confidential evaluations. Teacher evaluations are simply not subject to open records, and that's it. Additionally, when our Human Resources Department conducts an investigation, those investigative documents are not subject to open records until 10 days after the agency, the district, the board, is requested to take some action. So for instance, when we are conducting an investigation of an allegation of misconduct on the part of a teacher, and our HR department conducts that investigation, those documents are held accepted from open records until a recommendation is made to the board to terminate or not terminate or whatever. 10 days after that recommendation is made, those investigative materials become So, and again, these are the Attorney General's words. This is looking straight from the AG's office. There's a real commitment to open government. They want things to be open. They want the public to have as much access to the activities, the documents, the intentions of what every public agency in the state does. That's the overriding purpose of these sunshine laws. And hopefully, we will all stay on the right track.